Coming up next on Arizona Horizon, the U.S. Supreme Court rules on Arizona's congressional redistricting case. We will have legal analysis on that decision, and we'll take a closer look at the High Court's ruling on same-sex marriage. That's next on Arizona Horizon.
Arizona Horizon is made possible by contributions from the Friends of Eight, members of your Arizona PBS station. Thank you.
Good evening and welcome to Arizona Horizon. I'm Ted Simons. The U.S. Supreme Court today issued several rulings, including Arizona's congressional redistricting case, which we will discuss in detail in a moment. The High Court today also ruled that a controversial drug that's been shown to be problematic in administering the death penalty does not violate the Eighth Amendment's ban on cruel and unusual punishment. The 5-4 decision means Arizona and other states can continue using the drug. Executions in Arizona had been put on hold pending the Supreme Court's decision. The court today also declined to hear an appeal from former Arizona Congressman Rick Renzi, who was seeking a new trial after his conviction for public corruption and money laundering. Renzi contended that his work in Congress should not have been included as evidence against him. A lower court rejected that argument, and the Supreme Court today declined to step in. Renzi began serving a 3-year prison term in February. Maricopa County Superior Court judge today ordered Glendale to make a $3.75 million payment to the Arizona Coyotes. The city had asked the judge to withhold the quarterly payment or put it in an escrow account in light of a contract dispute between the city and the team. The judge denied the request but did increase the Coyotes' required bond to $1 million, a move to protect Glendale should it win the case. And Arizona will pay $670,000 to the families of the 19 Granite Mountain hotshots who died fighting the Yarnell Hill fire. The state says that the settlement does not assign blame and that the state agencies admit no guilt or negligence. The settlement comes a day before the second anniversary of the disaster. As mentioned at the top of the show, the U.S. Supreme Court today upheld Arizona's method of drawing congressional district maps. State Republican lawmakers had argued that the U.S. Constitution gives a sitting legislature the authority to draw those maps. Here to offer their perspectives on today's decision, Paul Eckstein, attorney with Perkins Coie, and Hugh Hallman, an attorney with the Rose Law Group. Good to have you both here. Thanks for joining us.
Good to be here.
Paul, we'll start with you. This was considered by a lot of folks a surprise. Do you agree?
I wasn't surprised. When you looked at the transcript of the oral argument, it was pretty clear that Kennedy was in play. He's often in play. He asked questions that I thought tipped his hand in favor of letting the process be done by the power of initiative. He's the only justice who is from up the western part of the United States where initiatives are pretty common. I think the dissenters in this opinion, the 4 dissenters, come from places where they don't have experience with initiatives, and they started with a bias against initiatives. But what was at issue in this case was the meaning of the term legislature in Article 1, Section 4 of the Constitution. The court held by a 5-4 decision that legislature includes the legislative process as done by the power of initiative in Arizona, which, by the way, is defined in the Arizona Constitution to include what is done by initiative and referendum.
Your thoughts?
The kinds of things only lawyers can get into, and I think Paul and I agree, this was not a surprise actually to me either, in large part because of the makeup of the court. We've had a number of 5-4 decisions, and these kinds of decisions, I think, for conservatives provide the fuel that demonstrates that there is more politics than law sometimes in decision making. In this instance, you've got Justice Roberts writing for the minority, indicating that the word legislature is used many times in the Constitution, and no place else could it properly really be redefined to mean the people of the state. It's certainly true, in my view, that there were other decisions earlier on that the courts made that gave one the opportunity to see that this is a decision that could be decided either way. And it really was up to judges, the justices, to decide which they want to go. As law professors taught probably both of us in law school, sometimes a decision is based on what the judges had for lunch. And in this instance, you've got a decision that could easily have gone either direction.
You agree with that?
No, I don't think it reasonably could have gone either direction. But what's really interesting here is Chief Justice Roberts' switch in position. When he decided wrote the majority opinion in the ACA case last Thursday, the Obamacare, He took words that the dissenters thought could only be interpreted one way, and he looked to the context of the statute, albeit that was a statutory construction case, not a constitutional case. But what Ginsburg did, in her majority opinion, was look to the context. And it's interesting that Roberts switched attitudes and ways of looking at it this time.
Of course, that's also true of the majority in this case. They've switched attitudes and positions on where they've come out in how they got to a result. In Obamacare, certainly in the marriage case, and in this one. I look at it trying to create a whole cloth here as the Obamacare decision was a very narrow decision trying to interpret some badly written language that Congress put out. And I could see how one could interpret it both ways. In this instance, the court really has looked at the language of the Constitution and then ignored it. You've got provisions in the Constitution that refer to the term legislature. Could you say that that means the people? Paul is correct, I think, to say that Arizona is a young state with our Constitution enacted when it was, adopted something fairly new, a concept of initiative. And the court sees that in its argument or in its opinion. And the majority said, let's look at the policy, let's look at the justifications for it. If you are a strict constructionalist and you read the Constitution's words to mean what they say, legislature has a very specific meaning. And I think it's, as pointed out by Justice Roberts, it's a little ironic that it was Arizona that was the second state that approved the 17th Amendment to allow the direct election of senators, where otherwise it was the legislature. And as he says, unusual language for a justice. What a bunch of chumps that they went through the process of amending the Constitution instead of just having this court redefine the word legislature to mean the people.
We've had some fun words, chumps and jiggery-pokery and pure applesauce, I think, was the last week as well.
Let me read to you what I think is the critical language in Justice Ginsburg's opinion. It would be perverse is the word she uses, to interpret the term legislature in the Elections Clause so as to exclude lawmaking by the people, particularly where such lawmaking is intended to check legislators' ability to choose the district lines they run in, thereby advancing the prospect that members of Congress will in fact be chosen by the people of the several states. By the people of the several states is the language that is used in Article 1, Section 2 of the United States Constitution. This particular provision that was adopted in 2000 by initiative is part of the Arizona Constitution, and no one doubts that it facilitates the will of the people.
That's a nice policy, but that's not what the U.S. Constitution is about. It's not for the several states or the people of those states to redefine the Constitution itself. And although Paul and I might agree that initiative is a very powerful and important tool in the state of Arizona, it's not for the state to redefine the Constitution. And that's exactly the point that was made with the 17th Amendment. The 17th Amendment changed the language of the Constitution that said that the legislature shall appoint senators. If, as Justice Roberts points out, legislature means the people, why did they bother?
I think Justice Ginsburg had the best of that argument. I thought she skewered Chief Justice Roberts when she said legislature means different things used in different parts of the Constitution. When they legislate, which is what redistricting is, even though Chief Justice Roberts said it isn't, it is legislating when you do redistricting. When you do that, it is done by the people in the state of Arizona, which is part of the legislative process.
And that reasoning now opens the Constitution to exactly the point. Whatever the justices had for breakfast or lunch, if they can now interpret words that are very clear throughout the Constitution to mean one thing in one place and something else in another, we get into trouble.
Hardly
and that's
clear.
Why conservatives are clear.
Hugh, hardly clear, because you just said, based on prior decisions, the court could have gone either way. I took issue with that and said no, it was clear in the way that Justice Ginsburg wrote her opinion. But if you say it could have gone either way, it's hardly the injustice that you pretend that it is.
And I said it was based on the makeup of this court. And you've got at least 5 justices willing to interpret the Constitution based on what they think it should mean today. There's certainly a school of thought that upholds that. It's not what conservatives view as appropriate. And that's why there's such debate about the court's decisions, especially when they're 5-4.
Well, with all respect, I think conservatives are all over the lot on this. I want to raise something that I think is very important. The decision is in.
And you make a good point. I want to grant that. You've got Republicans in California that
Indeed.
would cheer this decision because, of course, they
right.
are aided by the fact that there's an independent commission in California that helps them get more seats than they might otherwise if the very Democratic legislature selected them. So the partisanship that goes into this, I grant you.
Let me tell you about partisanship. The Republicans in the Arizona State Legislature expended somewhere on the order of $450,000 at a minimum to prosecute this action, and spent, in anticipation of a favorable decision by the Supreme Court, something like $60,000 to $70,000 on a firm that assists in the preparation of maps. Who's going to pay that? That is a partisan effort paid for, at least now, by the people of the state of Arizona. That's absolutely wrong. What we ought to be talking about is how that money is going to be paid back. Maybe the Koch brothers will write a check.
Okay. I want to get a couple of responses here.
Sure.
Justice Ginsburg, elections clause not designed to restrict, which is what the Arizona legislature was claiming. She's saying she understands the argument, but this is not what the elections clause was designed to do.
In fact, the irony is that the second provision in the elections clause gives Congress the authority to make the kinds of changes that she'd like to have made in this instance. But Congress didn't make that change. And so I challenge on that ground that you've got a specific additional clause in the elections clause itself that gives Congress that authority. And that Congress has not yielded or wielded that authority is troubling to me. By the same token, it means that if somebody wants to challenge this kind of a decision, they've got an open opportunity to go to Congress and seek enactments that make these changes.
The new path there. Okay, I want you to respond to Justice Roberts, who basically said the legislature does not mean the people.
He just said that, ipse dixit. Prior opinions of the Supreme Court indicate that the legislature, in connection with redistricting, in a case out of Ohio, in a case I think out of Michigan, said that the legislature can be something beyond the 90 people who sit at the end of Washington Street. A good example of that is, in one of the cases, the question was in redistricting whether the fact that a governor had the right to veto what the legislature did, was that something that went beyond Article 1, Section 4, giving the legislature the power. And the Supreme Court said, 100 years ago or so, no, that's part of the legislative process. The legislative process in Arizona clearly involves the initiative and referendum process.
Does this broaden the term legislature?
Of course it does, and that actually arguably is a tip to states' rights, and this is where conservatives, at least libertarians, might find this important. You've got 50 petri dishes in the states, and the court essentially has said the state of Arizona, through its petri dish and its constitution, has devolved upon the people some very direct authority to legislate. That's not true, as Paul mentioned, across this country. It's a progressive concept that was adopted in this state, ironically again, by the very people who decided that they would eliminate the state control of the Senate and give it to the people. That same group of people have now enacted something that has stripped more power away from the legislature.
Agree?
One thing I will agree with is that Republicans generally in Arizona have been opposed to initiative from the very beginning. There were 11 members of the Republican Party out of 55 at the Arizona Constitutional Convention. They, to a person, except one, objected to the power of initiative. That objection to allowing initiative and referendum as a check on the legislature has been objected to by Republicans from time immemorial. If this law had been construed by the Supreme Court as unconstitutional, it would have put in jeopardy all kinds of laws that have been adopted by initiative under the times, place, and manners provision of the Constitution.
Well, Paul would like to go back to the founding of the state to find Republican objections. The reality is that both parties have loved it or hated it, depending on which side of the issue they're on. Certainly, the Center for Arizona Policy loved it in 2008, doesn't anymore. And Paul's concerned that the Koch brothers will write a giant check to fund initiatives that they'd like to support. It is a matter of having enough money these days to gather the signatures and then win an election.
Can I make one final point?
Very quickly, please.
Hugh, there was a litigation in 2000. I was involved in it. Hugh was a witness, and Hugh testified. There wasn't any objection from Hugh or the Republican Party at that time about the unconstitutionality of the Independent Redistricting Commission. Now, when they don't like the maps, they object.
Quickly.
Of course, the Democrats will pick the shoe that they'd like to wear at any given time. I don't disagree with Paul that both parties like to get on the opposite side of an issue frequently, and it's unfortunate because it politicizes the law even.
Got to stop it right there. Great conversation. Good to have you both here. Thanks for joining us.
Thank you.
The U.S. Supreme Court ruled Friday that same-sex couples have the right to marry. It was a 5-4 decision, and it legalized same-sex marriages nationwide. Here now to discuss the ruling is Dan Barr of Perkins Coie. It's like our Supreme Court ruling special. Of course, this is the time of year. Major case. This may well be the landmark case of this term, though. You agree?
Yeah, this is going to be one of the historic cases of the Supreme Court. People are going to be reading 100, 200 years from now.
And Justice Kennedy, as is often the case, seemed as though he was the linchpin here, the key, protected under the 14th Amendment is what he's saying.
Well, all 4 Supreme Court cases dealing with gay rights have been written by Justice Kennedy. I mean, I think people will look at it as sort of the quartet of gay rights cases that he authored, and he'll go down as the leading voice for gay rights in this country.
Give me the case. I think there were 4 cases here, kind of combined into one for the Supreme Court here. Give us both sides. What was going on here?
Well, it was the same issue that was going on all over the country concerning the right to marry. And after the Supreme Court denied cert in those 7 cases last fall, it sort of unleashed courts around the country to recognize gay marriage. I mean, 2 days after the Supreme Court denied cert last October, the Ninth Circuit recognized the right to gay marriage. 9 days after that, Arizona recognized the right to gay marriage. So the issue that went before the Supreme Court was only one circuit had gone the other way, which was the Sixth Circuit. And so you had these cases out of Ohio and Michigan and Kentucky dealing with the right to same-sex marriage, and they were the same issues of whether your marriage was recognized from one state to another. In the case of Mr. Obergefell, whether his marriage would be recognized in the death certificate of his spouse, which is precisely the same issue that occurred here in Arizona with Fred McGuire, who brought in a claim, and Judge Sedgwick invalidated the Arizona same-sex marriage ban only to him, for one person, 1 month before he struck down the same-sex marriage ban. So
with that in mind, again, as far as Kennedy writing the opinion here, he wrote a lot about dignity, and the Constitution grants the right to dignity. The dissenters are saying, no, it doesn't. It's not in the Constitution. Dignity is not mentioned. Talk to us about that.
Well, it gets down to the fundamental way how you look at the Constitution. What Justice Kennedy says is you look at whether or not the marriage right is listed in the Bill of Rights. And if you don't find it there, then you look at whether it's considered to be a fundamental right under the Due Process Clause. And he finds that getting married and the right to marriage is a fundamental right, a liberty that's guaranteed by the Due Process Clause. And the way he reaches that is he looks at the precedent, and then he finds that, gee, we found that the right to marry is fundamental, and then he looks at why. And he lists 4 reasons why, and none of them have anything to do with whether you're a man or woman. And he finds 4 reasons. He finds first that the right to personal choice regarding marriage is inherent in the concept of individual liberty. Second, he finds that marriage supports a 2-person union unlike any other in its importance to committed individuals. Third, he finds that marriage safeguards children and families, that gives them stability. And finally, that marriage is a keystone to social order, that there are thousands of rights under federal and state law that flow from being married.
And yet, the dissent says that, and I think it was Scalia who said this was social transformation without representation.
Well, what the dissent is, all 4 dissents go off on is this is for the legislature, not for judges to decide.
Yes.
And Justice Robertson's dissent makes very clear, look, I'm sympathetic to gay marriage. I'm sympathetic to the rights of same-sex couples, but we're cutting short the democratic debate here. This should have been decided by the legislature. And they go on to say, and we shouldn't have judges determining what fundamental rights are, because while some people might like that today, you might not like it tomorrow when somebody else is deciding what a fundamental right is, and there's not much guidance for that. Justice Thomas goes even further by saying, well, liberty, as understood by the people who passed the Bill of Rights in 1791, only concerned the physically holding you by the state, whether they were detaining you or not, and has nothing to do with the state benefits.
That's interesting. That takes us off into whole different directions in a lot of ways. Okay, so you mentioned Arizona. It's already legal since the fall here in Arizona. But what about other state laws? What are the ramifications of this?
Well, when you take this opinion and you combine it with the Ninth Circuit's opinion in the Lotta case, that was the case where they struck down the Nevada and Idaho same-sex marriage bans. The Ninth Circuit in that case held that laws distinguishing among sexual orientation had to be viewed by heightened scrutiny. Before, they were just viewed under the rational basis test, which means that any laws making distinctions based on sexual orientation in Arizona in federal court will have to meet a heightened scrutiny test.
So that means the 1,000+ laws on the books that define man and woman as marriage, each and every one of those? I mean, you could fight. It
becomes much tougher for the state to defend those laws now than it did before. I would think a lot of those laws fall by the wayside under the reasoning of Justice Kennedy. If you look at what he's talking about, fundamental rights here, one of those is child rearing and the like, and those all flow from marriage. That the Supreme Court opinion standing alone would be good reason to strike it down. But the Ninth Circuit opinion in Lotta, where it says it's heightened scrutiny, the state is going to have a much tougher test in defending those. So I would think for a lot of those laws, which were based on an assumption that marriage is between a man and a woman, will either fall by the wayside, or you're going to have people in the legislature cleaning those up and making that clear that it applies to married people versus people who aren't married.
Discrimination protection, adding it to race, gender, religion, disability, those sorts of things. A possibility? Is it an initiative?
It's not only a possibility. The EEOC already has made the determination that discriminating people based on sexual orientation violates federal law. So the EEOC is already enforcing discrimination laws that way. Arizona is one of the states that does not have a law prohibiting discrimination against gays and lesbians. I wouldn't be surprised if you see a bill in the legislature, and if it fails there, to see an initiative go forward to establish such a law. And when that happens, I don't know, but it's only a matter of time.
What about religious liberty laws? Will we see a return of SB 1062? Can we see a return of SB 1062?
I don't know. I mean, since it failed the last time, it's gotten to be a lot more difficult for the people who would support such a statute. So I don't see that happening. If you did see it happening, I think it would have a counterproductive effect where you would say, gee, we need a law to prohibit discrimination against gays and lesbians. As for the tension between the religious community, I mean, first of all, there are a lot of people in the religious community who support same-sex marriage. I mean, this is not an issue of the gay community against the religious community. I mean, there are a lot of people in the religious community who support same-sex marriage. But to the extent there's any difficulty, I mean, that will be reserved be resolved by the courts.
And real quickly, in Texas, the Attorney General there says if it's a clerk issuing wedding licenses and you disagree with this religiously, you don't have to do it. Quickly. Could we see that in Arizona?
You can see it, but it's sort of nonsense. I mean, the clerk's job is to issue wedding licenses, and if the clerk doesn't like it, he or she can get a different job. I mean, the clerk is being paid by state money to do a job for the state.
All right. It's good to have you here.
Thanks
for
for
joining
having
us.
me.
Appreciate it. Tuesday on Arizona Horizon, Arizona Congressman Ruben Gallego will discuss controversial Sky Harbor flight path changes and other issues affecting his district, and we'll hear about new clinical trials aimed at fighting a particular type of melanoma. That's on the next Arizona Horizon. That is it for now. I'm Ted Simons. Thank you so much for joining us. You have a great evening.
Arizona Horizon is made possible by contributions from the Friends of 8, members of your Arizona PBS station. Thank you.